I am currently a complaint investigator at the Department of Education. So if you happen to be involved in a complaint or mediation or a due process hearing, you might hear from me or one of my cohorts. There is a small team of attorneys that work in special ed just dedicated to due process. That would be myself and Casey Symes, Stephanie Sloan, Dana Long, and Kim Payton. So you could hear from any of us if one of those due process proceedings gets started with your school. I was an elementary teacher and taught both gen ed and special ed students while I was in the elementary setting. I then went to law school, became a mediator, and now am in my current position as complaint investigator. So that's a little bit of history on how someone ends up in this unique position. We're going to be talking about Article 7. Raise your hand if you're familiar with Article 7. Good, we're off to a good start. All right, so Article 7 is really part of the Indiana Administrative Code, and it just happens to be what is Article 7, which are the special ed rules. So it is important to know for charter schools that all of Article 7 applies. Start to finish, every rule in there. Charter schools have a lot of flexibility, generally speaking, in their ability to run their school the way they want, but you do not have the flexibility to dismiss any of the requirements of Article 7 and what we do for our special ed students. I've already mentioned the 3 dispute resolution processes. When there's a disagreement with a parent or another party about the provision of special ed services. And that again is complaint investigation, mediation, due process hearings. We're going to break those down. I'm going to kind of explain how each works, give you some hints, some practical pointers on those, both how to avoid them and what to do when you find yourself in one. Because I can tell you this, schools can be doing absolutely everything right and find themselves sometimes in a complaint. Not every complaint that gets filed has findings of violation. So sometimes schools are absolutely compliant but still have to face the complaint and still have to go through the entire process. And I apologize for that, but that's the way. It's better to err on the side of investigating and not finding something than letting something fall through that should be corrected. So a complaint may be filed by anyone. A lot of times schools will say, well, this should be dismissed because it wasn't filed by a parent and that particular party doesn't have standing. No, actually Article 7 and the federal law from which Article 7 is derived, which is the Individuals with Disabilities Education Act, tell us that third parties may file for complaint investigations. So if you have a parent or a grandparent or even a friend of a parent who sees something going on and is concerned about it, that person does have the right to file a complaint. Now, having said that, we're not going to share with that party we're not going to share back with that third party any personal information about a student that's involved in a complaint. We just say thank you for this and we move on and we investigate. But with a parent, which is different with a parent, because a parent, we share what we're finding and the parent has the right to request any documentation that the school provides. That third party doesn't have that same right. So that's how that's different. The complaint alleges the school is not complying with a state or federal special ed or related requirement. It might allege that there was a prior mediated or written agreement and the school is not doing what they agreed to do in those agreements. We will enforce that through a complaint process. Or it might be enforcement of hearing officer orders. So in addition to what Article 7 says, if you enter into an additional written agreement or you've gone through a hearing and have orders, you have to comply with those additional requirements. Generally speaking, complaints involve one student. However, sometimes we have a complaint that a school is doing something wrong over and over and over with lots of students, and that's what we call a systemic complaint. So there are those two varieties. I wanted to take a moment while we're talking about complaints and hearings and mediations to introduce our new electronic filing system called iChamp. How many of you have heard of iChamp? Okay, this is good. So this is actually something new. All right. So we are in the process of development on this. It is live. It is usable. We're still working out the kinks. So if we notify you that we've received an electronic filing through iChamp, We're going to work together and we're going to get through it. Ideally, where we want to be is that a parent can go in the portal, file a complaint, and all the communication through that complaint or mediation or hearing process goes back and forth electronically, and it eliminates the need for excessive faxing and a lot of paperwork. We haven't had anything go completely paper-free yet. Like I said, we're in the process of using it, but it has eased up our communications, and the parents are liking working with it. So this is what iChamp looks like when a parent logs on. It lets them learn more about either the complaint, the hearing, or the mediation process, and it also has the green button for Get Started. They can actually do that filing online. I've got the electronic site there for you. If you'd just like to click on it later and explore, you're welcome to do so. But just want to make you aware of that. Let's talk about complaints first, because we have more complaints than we have mediations or hearings, and that's generally, if there's a problem, that's where parents go first. So what happens is the day one we get a complaint at our office, we're going to notify the director of special ed. Now, for charter folks, sometimes they have a director of special ed, sometimes just have a lead special ed person. Your title might be different. So if we call you and say, who's your director, work with us and make sure we have the right person. And for a lot of you, we already know exactly who that is, but things tend to change a lot in charter schools, and we realize that. And while I'm mentioning that, that's a good point. When you have a change of staff in your administration or your special ed director or someone at that level, please let us know so that we can update our files too. So you'll get notified, and what that means is you'll get a copy of the complaint, so you get to see exactly what the parent put in there. It is important to know that what gets investigated is not exactly what the parent writes in that complaint. The parents often will write things in a complaint that have nothing to do with special ed. I get a complaint that says my child's IEP is not being followed, and the school serves Frosted Flakes for breakfast every morning, and that's ridiculous. It's making my child fat. There's one issue I can investigate, and there's one issue I'm going to tell the parent, I get that you're upset about this, but this is not an investigable issue. So I give that kind of a silly, easy example, but to let you know that what you see in the complaint, when you think about how to respond to that, some of that may get thrown out, and some of it doesn't get articulated very well by the parent. So a parent may just say, the school's not doing what they're supposed to, he's supposed to get this, she's supposed to get that, and then we use the language, oh, so you're saying that they're not following the IEP requires X, Y, Z. So we fine-tune their language, and we issue spot and turn that into an investigable issue if we feel, based on the conversation with the parent, there really is one, and sometimes we eliminate things. So yes, we tweak the complaint so that it's a valid, investigable issue. Okay, so during that first 10 days, you have the opportunity to try to resolve the complaint with the parent. We're hopeful. We always encourage that you enter into a written agreement with the parent where everybody's happy and you've solved the problem on your own. Because ultimately, we're there with you in the complaint process, but if this is a young student, you're going to be working with this student for a number of years. And we want to help build that bridge, that collaborative relationship. And so we want you to take ownership. And if you can resolve it on your own, awesome. That's always the best possible outcome, is that first 10 days you call me up and say, you know what? I got a written agreement with the parent. And we're going to talk about how to get a written agreement later. So hold on for that. If you don't resolve, or if there is no response, we're going to begin formal investigation on day 11. That's when we give you a notification letter. The notification letter is saying, we're going forward with this, and the key thing is, I told you about me tweaking those issues. That's where I lay out for you exactly what we're going to investigate. Issue 1. Did the school implement the IEP as written? Specifically, did the school provide 20 minutes of speech per week to the student? Issue 2, did the school ensure that the CCC convened at a mutually agreed upon date, time, and place? So it's that using that language of Article 7, and the citations will be there. And then you know exactly what we're looking into, and those are the only issues. If other things come up during the course of the investigation, we go, ooh, that looks like that might be an issue too, but we didn't know that at first. Two things can happen. If it's early in the investigation, we can add an issue, but you'll get another letter telling you, hey, we've noticed this is going on. If it's later in the investigation, we've already started the report and there's not time to exchange documents and meet our 40-day timeline, then we will say to the parent, you have the right to file another complaint, but this one we need to really move on and just look at what we were looking at before. That doesn't happen terribly often, but sometimes it does. Okay, so you get the opportunity after this 11th day. You'll have 7 days from then, a full week, and we send you that by fax so that you have it that day. 7 days to prepare your responsive documentation. In that issue letter, we tell you what kind of documentation we're looking for. We're not trying to trip anybody up. What we list is what we think would show that you were in compliance. So if we ask for attendance records, we want to see when the student was or wasn't in class. If we ask for copies of emails with the parent, communications with the parent, just try to provide us what you have. If you don't have something, it's perfectly fair, and the best thing to do is say, I don't have that. Don't fabricate things or try to create what wasn't there before. All right. So on day 40, on or before, we issue a complaint investigation report that has findings of fact, conclusions. The conclusions will end up stating either there was or was not a violation. So if there were two issues, like in my example I gave earlier, the IEP implementation and the CCC date, time, and place, there will be two conclusions. There'll be a finding of either in violation or not violation on each one of those. If you don't like the results of the report in that you feel they are incorrect, you have the opportunity to request reconsideration by Dr. Wright, who you heard from earlier, to have her take a second look at it. Now, I will tell you that when you're at reconsideration, you don't get to introduce new documentation. It's just based on what documentation we gave you, we feel like you looked at it wrong, and we feel like that we really weren't in violation, and this is why. If there's new evidence that was never available before, you can introduce new evidence, but that doesn't come up very often. But anyway, there is that chance. It's like an appeal in the court system. And then that report, if we find that something needs to be changed, we'll revise that, and that will be out by day 60. Not 60 days after the 40, but 60 from the original date of filing. So going back now, I want to dig in deeper because you're here, and due process sounds scary. If this happens to you, you'll know what to do, and you'll remember me talking about it. You won't remember exactly what I said, but you'll be able to access us and know who to call, and this will make more sense. So this preliminary response in that first 10 days, you have the opportunity to respond to us by saying, go ahead and start the investigation. We can't work this out with the parent. Or, hey, we'd like to try mediation. The parent and I think if we just sat down with a neutral third party, we could work this out. Or you can enter into a written agreement with the complainant. If you enter into a written agreement with the complainant to resolve the complaint, it has to be a mutually agreed upon. This makes it, I feel like I'm being redundant, but it has to be a mutually agreed upon agreement. We've had some schools that just give the parent a piece of paper. Here's what we're going to do. You need to sign this, and it'll be over. And then the parent calls and says, they want me to sign this, and I don't really agree to any of that. That's not mutually agreed upon. So you sit down and you say, this is what we'd like to do to resolve this. And if the parent agrees, both parties sign it, and you move forward. If you have any questions about how to write a written agreement, you can call me or one of the other anyone in my office, and we will be more than happy to talk you through the process of how to write a written agreement. We know you didn't go to law school, and we did, and not to say we're experts, but we can help you write a simple document that will suffice and be compliant. We'd like to do that so that you do have a good written agreement. Now, I talked about mediation. That's one of the options that you can choose. Mediation can be used to resolve a complaint only where the complainant is the parent. This option is not open to those third party because we don't want to invite a third party in to discuss confidential information about the student. That makes sense, right? So a parent can ask for mediation. Mediation in the due process setting is the best bargain out there in the legal arena. The mediators we use for special ed mediations are also mediators that may do family law or civil law, and they're charging $200 to $300 an hour for their mediations that they do privately. And when you request it, the state picks up the bill, and so there's no cost to the school or the parent for that mediator, for that mediation. It's completely voluntary, so both parties have to agree to do it. If the parent doesn't want to do it, you can't force them into mediation. But we will recommend it. So if you feel like mediation would help and the parent's a little bit hesitant, again, call us in our office and we'll call that parent. We'll reach out and we'll talk to them and we will talk up the benefits of mediation. And especially me having been a mediator prior, I feel very strongly that it's a fabulous way to resolve things, and we will tell the parent, all the good reasons why they ought to be doing that. So we'll work together in that way. There's a 20-day timeline to complete the mediation when it's in conjunction with a complaint. And that's so if it doesn't resolve, we can still meet our 40-day timeline. Now, having said that, there is a provision in Article 7 that says going to mediation is one of the reasons you can request a tolling, which means a pausing or a stopping of your complaint. So if both parties agree in writing that, hey, we want to put the complaint on pause. We're hopeful it'll work out. We're hopeful we'll go to mediation and resolve it, but we're not sure. So we don't want to drop the complaint. We just kind of want to put it on hold. That's called tolling, and you can do that. And there's really specific language that we need to see from you to make sure both parties are agreeing to toll it, because our timelines, hitting our 40 days, is something that the feds monitor us at the state level on, and so we can only go beyond that 40 days if there's if what is in writing shows that agreement to toll was definitely in place. So I like using that option, because that way if you resolve 4 of your 5 issues but there's still one dangling and it comes back, we haven't lost 20 days of our investigation. We still have the full 40 days to really give a good investigation and find out what's really going on and write a good quality report. Sometimes we feel rushed when things don't resolve and we've used up 20 days in mediation. So again, if that ever happens, please contact us and we'll tell you exactly what language to use to make that happen. All right, so when you write that written agreement, if you go to mediation and you reach an agreement, your mediator will write the agreement. But if you're just working with the parent informally, you can also get a written agreement. That first 10 days you invite them in, you have a little meeting with them, and that doesn't have to be a CCC meeting. That can just be you and the parent with this written agreement to resolve. So we recommend that you might draft some ideas ahead of time of what that agreement looks like. Now, I told you earlier you can't just force them, but you can say, here's what we'd like to offer. But be prepared if they said, well, I like that, except for instead of 8 hours, let's make it 10 hours. So be prepared to make changes. So it's a working draft, but have it pretty much prepared, and you can work with us. We'll help you come up with that if you'd like us to. Share it with a parent, and a complaint at a minimum needs to have, or a written agreement that's resolving a complaint at a minimum needs to have the complaint number identified on it, the date, folks forget to put dates on things, your specific terms, what are you agreeing to, your resolution language, and both parties' signatures. Key language, if you want this to resolve the complaint so it goes away, and I know instantly that you all agreed, then term 1, we're going to provide 10 hours of XYZ service per month. Term 2, the student will be on a full day schedule starting September 21st. Term 3, this agreement resolves all issues in complaint CP 008-2017, and the parties agree that the complaint is closed. It's done. I don't have to do anything. I don't have to call the parent on that one because it's so clear. If that's signed by both parties, you're done. Good job. You get an A+ gold star. Okay, so what does a complaint investigation report look like? Well, it's a more formal document, but it identifies the issues, and we've already talked about this. I won't go into great detail. Has findings of facts, conclusions, and corrective action. So corrective action is only there if we find that there was a violation, and corrective action is what we ask that you do to remedy that violation or to gain an understanding, particularly where this is a systemic problem, so that you won't have those kind of problems in the future. Corrective action, if we can see that you clearly had an IEP that required certain provisions and you didn't give the student those provisions, we can offer compensatory services. Go back and give the student the hours that you didn't give them, whether you're giving those tutoring, after school, in the summer, make that up. Corrective action is frequently in-service training. Hey, school, you didn't quite understand this right, so we want you to prepare a presentation so that you'll learn and then share with your folks so that everybody learns and that we don't make these mistakes again. Corrective action is not punitive. We don't tell people to fire a teacher. We don't tell people to fire a paraprofessional. Having said that, there's a caveat. If, for example, and this has come up recently in some bullying complaints where there's been allegations that because of bullying of a student with a disability, the school did not provide FAPE. So in those instances, what we look to are your own policies and procedures. What's your rules for investigating bullying? Because Indiana Code, not Article 7, but actually Indiana Code, all schools have to have bullying rules and procedures. And if your procedures require that your teachers report any incidents of bullying within 1 day by the end of to an particular administrator, we're going to look to see that happened. And we're still not going to order that teacher, anything punitive for that teacher. We're just going to order you to go back and re-examine your policies and procedures and make sure that you follow them. So you might be going back and putting a directive to that teacher. In the future, make sure that you report this, and there's a note in their permanent file then. But we're not going to order that specifically. Does that make sense? Do you see the difference? We'll just tell you to go back and do what you should have done, but we're not punitive to the teacher level. Okay, common issues in charter school complaints. These are the big ones. I keep mentioning as my example just failure to implement the IEP. You didn't do what the IEP said to do. That's all parts of it. That's length of day, that's service provision, that's progress monitoring reports are being sent to parents. I mean, anything that's in the IEP, if the IEP says that you're going to do it, you need to be prepared to do it. Failing to comply with evaluation requirements. So you didn't make your deadlines, or you weren't timely. For whatever reason, something happened with the evaluation. Imposing impermissible conditions on enrollment or placement processes. You can't, and I think most of you know this, but I'm still going to say it, you can't tell folks they can't enroll because a student is a special ed student. That would be an impermissible condition. Unilateral decision making. That's the fancy way to say you didn't convene the CCC when you made a decision. You just wrote the IEP or changed the IEP on your own, and it was a great idea, and you know exactly why you did it, and there was data to do it, but you forgot to involve the parents. So even if you've got a great idea and you really know a kiddo's IEP needs to be changed, make sure we always invite the parent, even if it's a minor change. Another big one that we're going to talk a lot about today, discipline and manifestation determination process. That word just sounds scary, doesn't it? Manifestation determination. So we're going to dig in deep here in a few minutes on that one. Now, I added something from last year, and this really kind of goes back with the third bullet point, but it's in there because I've had 3 calls of concern since school started, and I've had a couple of complaints with charter schools. I don't even know where this came from. Literally, I learned a new word, and it's not a word. Don't use it. Unenrolling students. Schools can't unenroll students unilaterally. Okay? Schools can't unenroll students. Parents can withdraw their student because they no longer wish them to be enrolled. All right? I'm just flat out saying it because it's not at one school. It's happened at multiple schools. And let me give you a little background. So, student comes in, new move-in, school hasn't seen the IEP, student attends for a few days, now school has a copy of the IEP and says, well, oh my goodness, we've never had a student that has this particular need, and we have no teacher to meet this, and since we can't do it, you can't be here, go somewhere else. You took that student, you have to take all students, you need to find the services for that. Is it fair to convene the CCC and say to the parent, we don't currently have that placement. We're going to find a placement. We're going to enter into an interagency agreement to provide that placement? Yes, but now you actually still have enrolled that student, and you're now sending them somewhere else, and so transportation and all kinds of things are going to pop up. What's likely going to happen when you say that we're going to enter into an agreement and we're going to provide your services at XYZ school? The parent is likely going to say, well, if they're going to school there, why aren't they just enrolled there? And then you can say, well, that would be your option. And then if the parent says, I think I'm going to withdraw my student and enroll them there, that's fair. That's the way the process works. You can't just jump to all that yourself, even though you think that's probably where it's going to go up, and say to the parent, we withdrew your student or unenrolled because they need to go somewhere else. Are we clear on that? Thumbs up if we're clear, because I've had a lot of calls about it. Okay, perfect. All right, avoiding complaints. Implement your IEPs as written. I'm going to sound like a broken record today, and I apologize, but hopefully this will sink in. So your teachers of record should advise all gen ed teachers in writing of the accommodations and services to be provided to students. How many of you are familiar with IEP at a glance? The little summary page? Awesome. If you're not, please become familiar. It's a fabulous thing to hand to your gen ed teachers that have special ed students in their class, so they know exactly what they need to be doing for that student. Because the teachers do need to know the students' accommodations and services, and they need to be documenting provision. I'm going to give you an example of a complaint we had a few years ago. And I'm sorry if you were here last year, you've heard this before, but it's still the good example. So we had a complaint that the parent alleged the laundry list. Every single accommodation list in the IEP, the parent alleged the student wasn't getting the accommodations. Some things are pretty easy to prove a student is getting. If they're supposed to go to the resource room for test-taking purposes, and there's a sign-in sheet, here's the sign-in sheet, the student took the tests on these dates, great. Other things like extended time. How do you prove a student got extended time on a test? Does anybody have an answer to that? Any thoughts? How do you prove a student got extended time? You can make a notation, she said. You can record the start and stop time for gen ed and the special ed population. So gen ed students given half hour, student given 45 minutes, time and a half, or whatever the time is. So in this particular complaint, the parent was alleging the student never got extra time on their tests. And so when I said to the school, what did you do? And they said, well, we'll let you talk to our teachers. And the teachers are all telling me, of course we gave them extra time, but no one could document it. That hearsay, that's a report that you're just saying at the time of the complaint. It's not really admissible. You have to have documentation from the time things actually occurred. So we worked with that school and in other complaints, and a standard that's kind of been agreed upon is you don't have to write down every single time, but if a couple times a year, semester 1 and semester 2, let's say you're an algebra teacher and this student needs time and a half, when you give that first assessment of the year, make a notation on that student's test of whatever accommodations he was, provided. Extra time. Did somebody read it aloud? Was he pulled out and read aloud? Make a notation of that. Photocopy it. Still send the original home. Keep that photocopy in that file that you have for that student with their IEP at a glance. I know it's a lot of work. Do you have to do it? No. But if you get a complaint that you're not following accommodations and you can pull out that beginning of the year and show us, we're going to say, you know what? This school's clearly making sure their students get their accommodations. You don't need to do it on every one. Once a year, good. Once a semester, even better for those students. Okay? That was a practical pointer. Again, that's not a requirement, but it is a good practical pointer. It's good practice. Okay, so follow your case conference committee meeting procedures. Case conference meetings do need to be scheduled at a mutually agreed upon date, time, and place. So, most of us now have figured out the email is a really good friend to have in scheduling things. So you send out an email and say to the parent, we're thinking about this time, does this work? A lot of times parents are going to say, that works great. Then you can get on to Indiana IEP and generate your notice at that time. If all you do is generate a notice and the parent comes back and says that time doesn't work and you still have the meeting, there's a problem. You gave notice, but it wasn't mutually agreed upon. So make sure that you're communicating with the parent and make sure that you're documenting those communications, because there does reach a point. There are going to be parents who are going to email you 20 times and cancel 20 times. If you have tried 20 times to come up with a meeting time and you've failed, have that meeting without the parent and explain to them why, and we're gonna see that, and if you've documented that, you're okay. Because what's timely provision of services that the student needs is what is needed most, and that student need really is going to trump parent participation as long as you've made the efforts to involve that parent. Okay? All right. Again, the notice has to be in native language, so if you know that parent is a Spanish speaker, they need to get the notice in their language. So know that. And make sure all required participants attend. If the student is a gen ed student, you have to have at least one gen ed teacher there. That's the one that often doesn't show up. You can excuse them, but you need to have a signed excuse. And again, Indiana IEP is your friend. That form is on there, that excuse, and so make sure you use that and make sure everybody agrees to that. Conduct timely evaluations. So here's where it gets really tricky. A parent can make a verbal request, and that starts your timeline and that starts your process, even if it's verbal. If it's in writing, it's easy because everybody sees, hey, I think my student is having issues, and I think that they may need some special services, and here's why. That email, that's really crystal clear. But when a parent just says to a teacher, well, Susie's having trouble reading, and I've noticed that we've tried a lot of things, and we've tried, interventions, and it's just not working, and I really feel like she needs to be tested. If the parent goes home and makes a note in their diary or on their calendar that they talked to the teacher on that day, and we get a complaint that, hey, I made a verbal request, we're gonna, if they can in any way prove that they made that verbal request, we're gonna honor that, because Article 7 specifically says a request can be verbal. It's a tricky land to be in, but make sure that you honor those. So the big thing I want to tell you on this is reporting up. Your teachers need to be reminded every year that any request for an evaluation needs to be given to the appropriate director or administrator immediately. Don't sit on those because it's a timeline thing. Teachers are busy, and yes, that's one more thing, but it'll keep you in compliance. So just like I'm hitting you over the head with all this, don't be afraid at the beginning of the year to hit them over the head, because there is so much to remember. Let's not assume that our gen ed teachers remember everything. I like reminders. I think most people do. Rather have a reminder than miss something. So after you get a parent request, you have 10 instructional days to either send out a notice that you are agreeing to evaluate, and you list out all the different tests that you're going to do, or you can tell a parent within 10 days that you are refusing. You don't have to always conduct an evaluation. If your data clearly indicates that you're making progress with a student with other interventions, and you don't think that that they need to be evaluated, and your data clearly shows that, you can refuse it. But the parent then has the right, if you refuse, to challenge that. Okay? So you have to make the call, but make sure your data backs up why you're refusing. You can get into a lot of trouble there. If you even think there's a possibility that maybe you should evaluate, you should evaluate. Okay? After sending the parent the written notice, that's the written notice that you are proposing to evaluate, the parent must give consent. So it's a back and forth process a couple times. Parent tells you they want an evaluation, you provide notice, they sign the consent. That signed consent is what starts your 50 instructional day timeline, where you have to complete the evaluation and convene the CCC. Parents, in addition to just that right to have the CCC convened at 50 days, also have the right to request a meeting to have the results of the evaluation explained to them prior to the CCC meeting. So that means if that parent wants to meet ahead of time, your psych has less than 50 days to get those results and get that scheduled, because you have to have those results in hand to meet with them, with either the psych or someone else to explain them before the meeting. So you're earlier than day 50. So some schools get caught on that. And they also have the right to request a copy of the evaluation report prior to the CCC meeting. But they will check that. So if you're familiar with the form, how many of you are pretty familiar with the consent form? How many of you have never seen a consent form, and that's okay? Okay, so it looks like some hesitancy, but most of you are familiar enough. So those boxes are on there, those extra things the parent can request. Pay attention to those extra boxes because you're going to have to get your evaluation done a little bit earlier if they've checked those. And again, if you make sure your teachers know if they get any consents, any paperwork, any requests, send it up immediately. Don't hang on to it. All right, discipline procedures. So the case conference committee ideally should address behavior and discipline concerns long before we are talking about disciplinary changes of placement or manifest determinations. We don't wait until that day 11 or day 10, day 11. Inappropriate behavior, interference with the education of students or others. These are things that should be leading to considerations of a FBA and a BIP, even if the student's not a student with behavioral issues, not previously identified with behavioral issues. That should be a trigger. If you're seeing a lot of discipline with one of your special ed students, they may need to be reevaluated. And we'll talk about this more, but an FBA is an evaluation. All teachers and staff have to keep track of days of removal, and they communicate these to administrators. We get into trouble so many times where a teacher has removed a student from class and the administrator that's in charge of discipline is keeping track of suspensions and big, I call big removals, what you normally think of as removals. The student, was asked to leave at 10 o'clock in the morning because of discipline, and so that's a day of removal. And they think they're at day 8, but what the administrator doesn't know is classroom teacher on multiple occasions has sent student out in the hallway for the entire period with no books. Just go out in the hall and sit. That go out in the hall and sit for an hour is a removal, and that's a full day of removal because a removal for any part of the day constitutes a full day of removal. That's Article 7. So those all add up, regardless of whether it was a half hour out of class or a full day suspension. That each one of those is a day. You can discipline a student following your disciplinary rules, just like a regular student for 10 days. And the other thing is, again, have you heard me use the phrase document? I'm going to say that over and over and over. We like a well-papered file. Keep track of things. Make notes. If you're sending a student somewhere to do work that's outside of the classroom, on that work or on your note or somewhere, wherever you keep a log, make a copy of it, put it in their little file. Student was sent to another teacher's classroom to cool down. Services were provided. They were with other students. And we'll get to a slide where it clearly delineates what you need to do, so you'll have that, but make a note of it. And if you can produce that, great. The best thing to do, send that email, everything I just said in an email to the director of special ed. Just FYI, student was sent to another class today, but I did A, B, and C, so it did not constitute a day of removal. Because now you've date stamped that email, so now when we get a complaint and mom says, well, they had all these removals, and well, no, they actually had this. Well, but they were removed from class. You can say, aha, but look, I sent you this email day telling you that all this was provided. That is awesome documentation because it's from the date it really happened. It wasn't developed during the course of the investigation, which remember we talked earlier about. That's not very good documentation because it looks like you just made it up for purpose of the investigation. So that email to the director, just an FYI, student was removed today, this is why. And director, if you've talked about this, when you get those, that doesn't require any action at that time. That's creating that paper file. So if you need it for documentation, hope you never need it, but if you do, you've got it. Okay. So we've talked about the half-day removals. The bus. If a student is kicked off the bus, removed from the bus, told by the bus driver for whatever reason they can't get on the bus, even though it's not in school, even though they went to school all day long, that bus removal constitutes a day of removal. So that's one that also gets school sometimes. And then there's this one, okay? And it just seems like it's usually the well-intentioned, super sweet teacher. I'm going to call Mom. Mom, Susie's having trouble in class today and she's just having a bad day and there have been lots of tears and she just can't seem to get her work done and she's fidgety and I just really feel like it would be best for her to go home today and I'm sure she'll come back tomorrow and we'll just go over everything she missed. And that's so sweet and so nice and they do over everything you missed. But you know what? If the IEP doesn't have a part in it that says student parent may be picked up and that does not constitute a day of removal because everybody's agreed upon the student may sometimes need those days. If that hasn't been agreed upon in the IEP ahead of time, that sweet little call where everybody thinks that sounds like a great idea, when parent gets mad later down the road, that's a day of removal. Even though they agreed to come pick the student up, it's still a day of removal. Okay? So, yes, the question was, does the bus transportation only count if transportation is in the IEP as a related service? Correct? So, yeah, that would generally be true. But if, yes and no. For charter schools, let me clarify. A lot of times you don't provide transportation for students, so we're getting to two questions here. If you are providing transportation to that student and you don't one day, it is still a removal. But I want to...
If it's not related service.
Yes. But I also want to speak to something else, which is a question that's related often. Do you have to provide transportation to special ed students? Because we get this all the time. This is a good point to bring it up. Not if it's not a related service. Okay? So I'm answering two questions. I probably muddied the waters. I apologize. But any removal, just any removal. Protect yourself in any removal. Okay? Yes. Okay. So the question, restating the question, is going back to the parent call home. If the teacher calls home and says, I want to get more information. We're having some issues. I'm seeing some problems. Can you tell me what's going on? And in the course of that conversation, the parent says, you know what? It sounds like maybe I just need to come pick up my student today. That's the parent's unilateral decision. I would have them, if they feel adamant about coming and picking up their child, they need to email, they need to do whatever process the school normally does for an early dismissal, a parent-arranged early dismissal, and make sure that's clearly communicated. That say, well, okay, can you follow up? Can you send me an email just for my records, could you please send me an email telling me what you just told me over the phone so I have for my records why you're picking her up today? And then if you've got something that the parent is saying, I'm picking up my student, for whatever reason, that's the parent's decision. And in that case, if you had that email, that would not be your decision. That's not the school removing the student. That's the parent removing the student. Okay? But be careful on that one, because if you're like, well, some parents might pick their kid up and you're hinting at that, that's not going to play well with the parent. And if they're concerned later, that's still going to come out, and that just doesn't look, you know what I mean? So, but if legitimately a parent could say that, or maybe maybe they're having that bad day, and when you call the parent, they say, you know what? She had a horrible migraine last night, and I kind of thought today might be a bad day, and so I'm going to go ahead and schedule an appointment and take her to the doctor. Great. Have them write that in an email, and they take it, and that explains why you're seeing that behavior that day. Okay, good question. Yes. Yeah, absolutely. So her question is the 10 days for a particular type of thing, or is it for 10 days for anything? Like, can it be different types of behaviors that those days of removal are occurring? And she's my plant. I put her in the audience because we're going to that soon in our slides. So if you just bear with me, we're going to answer it, and I'll let it occur naturally in the slides. But the answer is, it depends. The legal answer, it depends. So we'll get there. So make sure, directors, administrators, that all your teachers are familiar with Rule 44 in Article 7, which contain the guidelines for discipline for special ed students. It is scary. It is hairy. It's difficult language. So we're going to work through some of that language today, so hopefully you become more familiar. So as you work with your other staff members, it'll make more sense to you. All right. Discipline is more than suspension and expulsion. Really, discipline, to avoid discipline removals, we should be having good discipline training to produce a specified character or pattern of behavior. Those things that are in the BIPs, those interventions, those strategies, that's all really part of what we should be thinking of when we think of discipline. We shouldn't just be thinking about what happens at day 10 or 11. So we want to have controlled behavior resulting from training. The CCC should be addressing behavior long before students' behavior leads to a disciplinary change of placement. So inappropriate behavior, interference with education of the student or others should lead to consideration of a FBA and a BIP for any special ed student. If the student's speech, language only, but you're seeing repeated behaviors, something's going on. Go ahead and conduct. You don't have to do a full-blown evaluation. You don't have to do every cognitive test, but propose to the parent that you collect some data and you do an FBA so you can determine whether or not you need to develop a behavior intervention plan. So FBA, Functional Behavior Assessment. It's a process that uses data to identify patterns in the student's behavior and the purpose or function of the behavior of the student. It is an evaluation. Parental consent is required. A lot of times we'll have schools say, we were just doing an FBA. You're still collecting data that's going to be used to make decisions. That is an evaluation. Okay, so you have to do the FBA to develop a behavior intervention plan. If a student is going to be suspended for more than 10 days in the school year, expelled, or if a behavior involved possession of weapons, drugs, or result in serious bodily injury, you actually are required to conduct an FBA. However, just because you're required that time, that doesn't mean you have to meet one of those. You can do an FBA anytime you feel like there's a need for one. There's no requirement that the student be facing disciplinary action before doing that. However, there is a requirement that you get parental consent. All right. So the Behavior Intervention Plan is a plan agreed upon by the CCC and incorporated into the IEP that describes the pattern of behavior, what were we seeing, and how is it impeding the student's learning or the learning of others. What is the purpose or function of that behavior? In other words, why is the student doing what they're doing? What's the underlying reason? Or what do we think is the underlying reason? And, where are we going to go? What are we going to do? Positive intervention and supports and other strategies to address the behavior. A good BIP is not, student is hitting and kicking and biting. Student will reduce hitting and kicking and biting. When student hits, kicks, and bites, they will get a hot pass and go to the timeout room. I see that a lot. What are you going to do to teach that student not to hit, kick, and bite? Are you going to have them work with the counselor? Are you going to provide a specific training series? Are you going to invite the parent in to talk about what's working at home? List what you're going to do to get there. That's a much better BIP. Okay, so if applicable, make sure that the skills that will be taught and monitored to change the behavior are listed. So we want to have a behavior plan that works across settings. We want to make it clear. We're going back to remember all the teachers that work with the student have to be aware of what's going on. Has to be a very clearly articulated list of strategies so that anybody can pick that up and implement that. Does that make sense? Okay. Also in the BIP, if the parent says and this goes back to our day of removal. This is where if the parent says, there are just days where the meltdowns are so bad. Once the hit the floor, thrashing the leg goes on. I know my child. Once you get to that point, he's done for the day. She's done for the day. If that happens, please call me. I want to come. I would rather come pick her up than have her spend a miserable afternoon at school. If the parent says that to you and you have data that kind of reflects that, ultimately you want to get to where you don't have that behavior, right? So that needs to be in there. But right now, at this point, you're all agreeing that there are days where parent wants to pick student up. That needs to be in the BIP. And it's not the first strategy. It's after you've tried multiple things. And if this triggers this and you see this, school can call parent and parent agrees that they will come pick up the child. And here's the magic language. This will not constitute a day of removal. Put that in your BIP And it's crystal clear when it hits the complaint investigator's desk that that did not constitute a day of removal because you thought about it ahead of time. Okay? Good practice pointer. So during that first 10 days, you're not required to provide services when the student violates a code of conduct or otherwise has a disciplinary issue, so long as you treat them the same way you would treat a student without a disability. Okay, you can't discipline different. You can't have different rules. Yes, question.
Sorry. Okay.
Yes, very good question. The question is a very good one. So you have a move-in student whose prior school developed an FBA or did an FBA and developed a BIP, and you know for your school you have different rules and different processes. That's not going to work. It's not workable. Do you have to call the parent in? Yes. And oh, by the way, if it's a move-in student, you should be conducting a move-in conference within 10 days anyway. So you have, that would be a good opportunity to do it. Where am I? So your move-in conference, and move-in conferences, until that first, within 10 instructional days, you have to provide comparable services. So if you don't have something that other school had, come as close as you can, and you're under the umbrella in that first 10 days. As long as you made a good faith effort to offer something comparable services are okay up until that point. Is that good? But make sure that you are revising and tweaking that BIP part of the IEP at that move-in conference. Thank you. Good question. Okay, so this last bullet point here was what we talked about, that language, the short-term removal for a student pursuant to the student's IEP. That's fancy language that you thought about it. It's in the IEP that you can do that, and parent agreed to it. Okay. Now we're going to get to your question. Okay, removals. If a student is removed for more than 10 cumulative instructional days in the school year, the school must determine if a change of a placement has occurred. Cumulative is not consecutive. If it's consecutive 10 in a row after the 10, you have to do the manifest. If it's cumulative, like you said, it was 3 for fighting, it was 2 days for whatever reason, bullying or whatever it was, then those you have to make the decision. The school has to determine if there was a disciplinary change of placement. Disciplinary change of placement is triggered when there has been a series of removals that add up to more than 10 instructional days, and the student's behavior is substantially similar to the behavior in previous incidents. You're going to look at factors such as length of each removal, cumulative amount of time, and proximity. In other words, how close was this behavior to other behavior? So, for a student, and the other factor you're going to look at is the student, the individual student. So, as an example, let me give you an easy one. Student is a student who has an IEP. They receive speech services only. Okay? They don't have a history of behavior issues. There's no emotional disability. There's no cognitive disability. It's speech only. They are suspended 5 days for an incident that occurred on the bus where they got into a fight. A few months later, the school has a provision where, and I don't like this, but if they miss so many days, they're tardy so many days, they're suspended. First of all, I want to back up and say I think that's a bad practice, but schools have those rules, so they lose time there. And then there's another incident, totally different situation that involves some aggressive behavior, but it's different than the other situation. The school could say, you know what, yeah, we hit 10 days, but these happened at different times. They were different students, different triggers, and they have nothing to do with this student's disability. So we really feel like we disciplined this student appropriately and fairly, and it wasn't a change of placement. Okay? The parent can challenge that. Parents will likely challenge that. When parents of students with disabilities have the extra protections, and the right to do that, and so a lot of schools, just as a default, even though they have the right in Article 7 to say that was not a change of placement, what a lot of schools have opted into, this is across the country, have opted into an automatic. If it's 10 days, we're going to just do it automatically. And then you don't have to wiggle with whether or not it constitutes a change of placement, and you don't have to defend your position. But you have the right to make that decision if you don't believe it was. So if you believe the removal is not a change of placement, okay, because the removals did not constitute a change of placement, and you were able to have data to show that, you still have to provide services. If it's not a change of placement, you still have to provide services. Because I will have schools say, well, we didn't conduct a manifest and we didn't provide services because we determined it wasn't a change of placement. Well, you still suspended the student for more than 10 days and they went without services from day 11 on. You still have to provide services. So just make sure that you're clear on that. Just because principal says it was not a change of placement, you still have to provide services after day 10. And continuing to participate in the Gen Ed curriculum, although in another setting, you're making progress towards the goals in the IEP. That would be services. If the removal is a change of placement, and again, a lot of schools just automatically are going to consider anything beyond 10 days, that is a change of placement because that's the easy way to do it, and we're not going to be in trouble by treating it as if it is a change of placement. That's giving more protection, and you're allowed to give more. You can't give less, but you can give more. So when a decision is made to make a removal that constitutes a change of placement, the school must notify the parent and provide the parent with a notice of procedural safeguards. Did you know that? Because I often forget that too. I mean, that's one of those times where you actually have to give a copy of NOPS, your notice of procedural safeguards, when you change that placement. And if you don't actually give the parent those, that's a technical violation. I know that's one of those quirky things that people forget about. The notice must be provided on the date the school decides to make a removal that results in the change of placement. So what does that mean practically speaking? On what number day do you have to give the notice? Anybody? It's a math question. On what day of removal do you have to give the notice? Yes, 11th. Yeah. Okay. So you have to be keeping track because you have to know as soon as it happens. Not calling them a week later and say, oh, we noticed that we went beyond our 11 days doesn't cut it. Manifestation, determination. I want you to keep thinking two because we're going to get to this, but just keep thinking manifestation, determination. There are two prongs to a manifestation determination, and we often do prong one and we often forget prong two. So by going 1, 2 lots of times a day, I'm hoping that you'll burn in your brain there are two prongs to it. Within 10 instructional days, not calendar days, but instructional days. And who can define instructional day for me? I know most of you probably can. What's an instructional day versus a calendar day? Yep. If the students are in school, it's an instructional day. If it's a teacher in-service days and students are not there, it is not an instructional day. So there's an instructional day. Within 10 of those days, any decision to change the placement of a student with a disability for violating rules, the student's CCC must meet to determine whether the student's behavior is a manifestation of the student's disability. So, suspensions that result in suspension for more than 10 consecutive days, series of suspensions constituting a pattern, expulsion, any of those things. Those are all reasons you got to look at it. So, manifestation determination. The CCC must review all relevant information, including the IEP, teacher observations, and information provided by the parent. Here's our 1, 2. 1, determine whether the behavior was caused by or had a direct and substantial relationship to the disability. If you majored in special education, you answered something like that on a question at some point in your schooling. Everybody knows that direct and substantial relationship to the disability. What people forget, practitioners forget often, is you also have to determine whether the behavior was a direct result of the school's failure to implement the IEP. Okay, so the behavior may have had nothing to do with the student's IEP. Go back to my speech kiddo example earlier. Okay, that discipline had nothing to do with that. However, school wasn't providing services, and maybe they were supposed to, check and make sure hearing aid was working, and the student had something to do with speech, and the kid was getting made fun of, and then he punched another kid because there was a problem, and the kids were making fun of him when he went out to speech class. That kind of has, if you've said you're going to do something and you're not doing it, however convoluted it is, and because of that, a problem occurs, that could be related to IEP. So just walk down both prongs, 1 and 2. Where this really comes into play, though, that's the best example of where this comes into play is you didn't implement the BIP. You didn't do everything. The kid has a perfectly good BIP. You know this is a kid who can have explosive behavior. You know this is a kid who, if other kids start calling him names, he's going to take it for about 1 minute and then he's going to explode. So when you hear that, he's supposed to be given access to a hot pass. Well, math teacher that day was given a very important test and said, I'm not giving any passes out to anybody. And so when kiddo asked for a hot pass, no, take your test first. And the kid exploded. And the kid punched and kicked and hit and cussed. You know? So then that failure to implement the BIP, that's what led to that. So, you know, make sure you do both parts of the analysis. And when I say do both parts analysis, I want to be very practical. I want to be very hands-on. When you conduct a manifestation determination, where do you document what you talked about? Where do you document it? When you do a manifestation, those of you that do them, where do you document that? In the what? In behavioral considerations. Where else? If you're having a manifestation determination and your discussion of whether or not it related to the disability and your discussion of whether or not the IEP is implemented, where do you think you should put that in your IEP? I think someone... There is a manifestation section, but also the written notes work very well. If you have a lot of lengthy discussion, you can put in the written notes in the follow along and all the considerations that you looked at. So when we see that analysis that you march through that and we can follow along and let's go, wow, look, they considered this and the parent and the school talked about this and, you know, good. That shows that. So make sure that you're documenting these discussions, not just that you do it, but compliance is all about documentation. If you get called out on this parent alleges you didn't do something and you can show in your documentation that you did and you did have that discussion, you're covered. Okay. So if the conduct was a direct result of the school's failure to implement the IEP, the school must take immediate steps to remedy the deficiencies. You have to take immediate steps. So what you have to do is you have to look at FBA. You have to determine, you know, what changes need to be made to BIP and that sort of thing. If the behavior was a manifestation of disability, the student must be returned to the placement from which he was removed unless he's been placed in an interim alternative education setting, IAES, for conduct involving the possession of weapon or drugs or for causing serious bodily injury. Those are the reasons why you should be doing that. And IAES is not because the kids had a series of name-calling incidents and he has hit 1 or 2 students. Hitting a student is not serious bodily injury. So they shouldn't be in that placement in that situation. All right, and I already mentioned this. You have to conduct an FBA and develop a BIP unless you had a recently conducted FBA. And if a BIP was previously developed, you must review so at a minimum, you have to review the existing BIP and modify it as necessary. So if you are having the manifest determination and you look at the BIP and you think, parent and school agree, you know what, this is a great BIP. This behavior still occurred, but this is still a good BIP. I would, in my written notes, I would say parent and school reviewed the BIP and agreed it was still a good BIP, so no changes were made. Because if you don't do that, it looks like you didn't review it and make changes. But if you agree no changes need to be made, let's document that. All right. So if you determine that the conduct was not a manifestation, you still have to determine what appropriate services need to be provided to, and I think this goes back to your question, sir, what do you have to do? So you have to, in the IEP, determine how are you going to enable the student to continue to participate in the gen ed curriculum, how are they going to progress toward meeting goals in the IEP, and make sure they receive an FBA and behavior intervention services designed to address the behavior violation so it does not reoccur. So these are the things, these are bullet points, are the discussion points that should be in your manifestation determination notes. If the student's parent disagrees, if the CCC overall finds that the manifestation was not, the behavior was not a manifestation, the parent has the right to object and request a mediation, a due process hearing, or both. This is not a complainable issue. We have to tell parents will write a complaint. Oh, I disagree. The school found that it was not a manifestation. And that's when we as investigator, we might get that complaint, but we're going to tell them, you need to either file them for a mediation or a due process hearing on that issue. Yes. Okay, so the question was, if you're wanting to find out what's going on and get some behavior data and do a BIP very quickly when discipline's at issue, is there an additional timeline? There isn't. It's still that 50-day one, but that, like you've already answered it yourself, I think. You know time is of the essence, and it's better to move quickly on that. I mentioned that IAES, that's kind of a scary thing to people. People don't know when it can be used and how it can be used. This is one of the few times in special ed the school just gets to do something. That you don't have to convene the CCC. The principal or the principal's designee can just say, this behavior is so dangerous that we're going to remove this student for 45 days. But because a removal for 45 days is without a CCC, is a very serious removal, it has to be because a serious safety concern. So it has to involve possession of a weapon or illegal drugs or serious bodily injury. Serious bodily injury is somebody went to the hospital because their arm was stabbed and they were bleeding profusely, and had they not went to the hospital, they would have bled out. That one's going to be serious bodily injury. A black eye, not serious bodily injury. The continuum of things in between that, it's a judgment call, but you're going to have to defend it was a serious bodily injury. It's not a minor incident. Okay? Stabbing a teacher with a stapler. Courts found not serious bodily injury. Okay? So that's a legal definition. Serious bodily injury is a legal definition. So you can, I didn't bring the definition, but it's much more than a minor incident. So it takes a lot. Suspension and expulsion. Make sure you have discipline rules for good school policy for all students, and make sure that your special ed students are held to the same accountability rules for those. And again, just remember, this is just kind of a summary. Removal for any part of the day constitutes a day of removal, but not if you have it in the IEP, that it's not. That's okay. We talked about that earlier. And in-school suspension, somebody asked this question earlier, and I said we would get back to it. An in-school suspension is not considered a removal if the student has had the opportunity to progress in the general curriculum, receive special ed services specified in the IEP, the gentleman back there asked about that, and participate with non-disabled students to the extent the student would have in the student's current placement. So you can remove them. So kind of like when I go to conferences, they say one of the best places to remove a student to is another class that's the same class. Okay, like in other words, if they're in a Gen Ed 5th grade classroom and there's 2 Gen Ed 5th grade classrooms, put them in that 5th grade classroom. If you're a small charter school, maybe you could justify, I put them in the 4th grade classroom because it's similar and I made sure that I provided their materials and they were working on the materials, but because they just needed a break from these kids because they weren't getting along today, but they had services, and I checked in frequently to ask questions, and that teacher asked if they had any questions about their work, and they went to lunch still with the same group of kids. They had all these pieces in there, but you've got to document what you did to cover each one of these, or when parent calls into question the number of days of removals later on, that's going to look like a day of removal. But if you can do all these things and you can document it, then it's not a day of removal for in-school suspension. All right, how do you avoid complaints? Number 1, communicate with your parents. Encourage frequent communication, and don't wait until there's a problem. Lots of positivity, lots of open communication. The best line of defense is just that. Maintain that good communication. Remind parents to contact teachers if there's a problem. At the beginning of the year, teachers should be saying that. At the beginning of the year, newsletters from the school administrators should be saying, if you ever have a problem, feel free to contact your teachers. Our teachers love to talk to parents, and I think we all do that, but let's not forget that it's important. When in doubt, communicate with special education staff directors. So if you're not sure if you're doing something right, ask a question. If you're the director or you're the administrator, make yourself available. Open up to your teachers. Please ask me questions. I'm at the state level, right? I'm a state level, over due process. I love when people call me ahead of time. I love when people say, hey, I'm not sure what to do. Can you tell me what to do? It might take me a while to find the answer, and I might have to call someone else, but I would much rather answer your question, your compliance question proactively and avoid a complaint than be talking about it reactively when you do have a complaint. So, if you're a director or administrator, kind of keep that same mindset with your teachers. Remember, their questions are keeping you in compliance, because if they really have a question, let's figure out the answer together. And if you're the director or administrator and you don't know the answer to your teacher's question, say, you know what, I don't know, but call this person at the state. If it's a special ed question, we'll work with you. We like to do that. Mediation can be used to resolve any dispute related to special education. So you don't have to wait for the parent. If you know there's a problem and you're like, I get the feeling this parent's going to file a complaint, they're really not happy, we're not sure we've done everything right, you can say to the parent, would you like to go to mediation? Because I feel like we're having a problem here, and I think that having a neutral third party would help. The other thing that's not on my list, because it's not technically under due process, but it's amazing, is facilitated IEP. So if you feel like there's a problem with a parent that could result in a complaint, call and request a facilitated IEP. There is no cost to do that, and that is a wonderful service, much like mediation. They're actually very similar, except for mediation the mediated agreement doesn't change the IEP. When you do facilitate IEP, that third party helps you and you change the IEP that day. Just really being proactive. All right. So mediation, we've already talked about that it can be used to resolve complaints. It can be use it to resolve disagreements with your parents. We've already talked about we provide the mediator. It's really successful when both people want to try to resolve it. If you've got a parent that's really, 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 really angry, it may not be your best option, but you can still throw it out there as a possibility. Due process hearings, that's most schools. I'm not going to spend a lot of time talking about due process hearings because all schools in Indiana, it's not required, but generally speaking, you use attorneys when you get to a due process hearing. And your attorney will walk you through and will kind of lead you through that process. But the issues, evaluation, identification, eligibility, services, placement, reimbursement, provision of FAPE, all those are in there. Now, parents are often not represented. They're what we call a pro se or self-represented party. But generally, schools are. Requests for due process hearings are only from the parent or the student if they're 18 or the school. We don't have third-party hearings like we have third-party complaints. And a hearing are for things that happen back to 2 years, a 2-year statute of limitations. So something could have happened a year and 9 months ago to that student. They can still ask for a hearing. With a complaint, there is a 1-year statute of limitation. Okay, so when the hearing, you want to just really quickly overview that. The request is filed for a hearing. The hearing officer is assigned. The school prepares a response. That's a very legal response to the issues. So again, the attorney is generally going to work with you to prepare that. If you get a request for a hearing, contact your attorney. That's what you need to do, and then they'll tell you what to do next. So we're going to give you, you'll get a written decision at the end if you all don't reach an agreement during the resolution session, and there is an opportunity for a formal appeal. How do you get to due process hearings? Differences in philosophies, methodologies. What does the student need? What's appropriate? You and the parent just can't see eye to eye on that. It stems from a breakdown in communication. Regrettably, sometimes just personalities. It's not a good match. But those disagreements often start at the CCC meeting. A parent walks away disgruntled because they didn't understand why the decision was made that was made at the CCC meeting. So good communication. And I leave you with my takeaway that I've already told you. I've just put it here in writing. It's usually better to make a phone call and proactively ask for technical assistance rather than wait and respond to a complaint or due process hearing reactively. So don't be afraid to call. I've got my number there. I've got my email. And I did have one question from online. Do you have to conduct an FBA before writing a BIP? Yes, you do need to do. You need to get that data, need to collect that, and from the FBA, functional behavior assessment, that is how you develop the BIP. So now you and the parent can agree to different things. You can have what looks like, you can say, we're going to try some things for behavior informally if you're having some small issues, but you really, if you are getting to the point where you're writing a BIP, evaluation is needed. You need more data. Yes. But in the interim, can you write a list of things you're going to try? And can you agree that in the IEP? Yes. But let's then go ahead and conduct the FBA. Any final questions? We're out of time. Really, I will be here through lunch, and I would be happy to talk with any of you. Please don't hesitate to email or call. Thank you for your time and attention on this very dry subject matter.